Every day in the USA, people find themselves in court.
Said he was going to get the form given to Danny because he had to take over.
We call 21-38410, the state of Texas versus Clayton Foreman.
He didn't change on the weapons, yes. So, I think you'll know.
You were Mr. Foreman?
Yes, sir.
Present. Mr. Burbank, your attorney and the state's counsel. Okay, today, what's our plan, please? Thank you.
Judge, the state of Texas has filed a motion to allow one of its witnesses, Dr. Charles Harvey, who's the forensic pathologist in this case, original forensic pathologist, to testify via Zoom. Now, I know we had a hearing before and talked about the confrontation issues, but we're coming before the court because we have case law and a statement from the doctor attached to the motion that the doctor physically is unable to travel the distance to Beaumont without giving him severe health risks. And so the case law provided in our brief that the court should have a copy of states that although it is preferable to have a face-to-face confrontation of the witnesses, that there are certain times when public policy, which would be preserving health, preserving life, would override the face-to-face and allow a person to testify via Zoom or some other teleconferencing. So we're asking the court to find that the doctor, and we do have the Dr. Charles Harvey, who is the witness and is also a physician, is present by Zoom. That's him up on the screen right now. In case the court needs to hear from him, but we also have a statement from his physician that's treating him that talks about that he does not recommend the travel because of the health issues.
You seen this motion?
I just saw it this morning, Judge.
You've probably been aware, though, of the
I've been
substance
aware,
of the issue.
and I have a request of on that, Judge, in reference to my formal.
Go ahead.
response.
What's your?
Number one is I would ask that you would give me at least till 5 o'clock today, because I just received this morning.
Okay.
But I would point out, Judge, that page 5 of 7 of the state's brief is that the case concerning the interpretation of Haggard is still pending before the Court of Criminal Appeals, and that's why I think I need to file a response. They cited a number of cases from around the country, but that's not Texas. So I request that. I know we have the doctor on video there, and we can proceed with the hearing with that. Second, though, thing, Judge, is that what is attached to State's Exhibit number 1 in reference to the state's motion, I'm going to object to. That is from somebody by the name of Robert Samuel. I don't know who Robert Samuel is. He says he's a doctor. He's Dr. I guess Dr. Harvey's physician, but that's just a message. It's not notarized. It is not authenticated. It's a message to somebody in reference to whatever. So I object to.
I don't know what you're talking about.
And Judge,
Here it is right here. I think I might have the state's exhibit 1.
All right, I'm gonna need a copy of this.
yes, sir.
I
Judge,
see
we're
that
going to tender it.
That's the physician, the attending physician of the witness.
And Judge, for this hearing, we tendered to State's Exhibit 1 and under the rules of evidence, whenever you're dealing with a matter, whether it's admissible or not, you know, that's what we're talking about here is the admissibility of this testimony by via Zoom, that the rules of evidence do not apply. So we're just tendering this, and we have Dr. Harvey here to testify as to what this says. He's also a physician and can understand and talk about his condition if the court wants to hear from him.
What do you say? What's your contention in all of this? What's your response?
Well, I think that Mr. Foreman has a right to confront the witnesses, especially at the date in reference to this happened, 1995. You're talking about a lot of things that have gone under the bridge in reference to water. And so in order to, the importance here is to piece everything from 1995 to the present and what they did. We know what happened and we know what the result was. But in order for the state to be able to prove beyond a reasonable doubt, there's a lot of pieces I know they have to be put together. But in the same token, he has constitutional rights, and one of them is the confrontation clause over this.
Why isn't that being met by a Zoom?
I think
A
that,
Zoom presentation? What
well,
is it that you can articulate that you can't see in a Zoom that you could see in live?
well, he was the actual pathologist.
Yes.
He also took a lot of the physical evidence that was used for DNA purposes.
I mean, can't he present that through Zoom?
Yes, sir.
Well, what is it that's different though for
Well, I think the
no,
courts.
hold on. This is important.
It is.
And we have, in spite of what that statement says, where does that confrontation in the Constitution exist where it has to be live and in person in front of a jury, or else it's not constitutional?
Well, and if it goes back, and there again, that's the reason why I asked for a little bit of time, because I just received their brief. They cited cases, especially Haggard, that they're relying upon state. But that's still pending in the Court of Criminal Appeals. That is not a done deal. You do have federal case law, but we're in the state of Texas. So, I mean, that's the reason why I asked for a little bit of time, so I can go back and present my argument there. But it's an unsettled matter, I believe, in the state of Texas. I know that we kind of went off on a tangent a little bit during COVID. We allowed some things to happen, Zoom, we're by that.
Let me ask you this. This is not something we've just thought about. This is something that we've been dealing with since COVID, because that blew up and courts have ruled permitting presentations. Most importantly, the defenses always in these presentations by Zoom have not objected to it, and we go over that and sign that. But confrontation, again, it's not specified what that really means. But is there not really a difference? Importance of a live witness when it is a person who is a witness, an actual witness to an event? Is that not listen to the distinction this court just readily sees, especially since COVID has come about, where we have used presentations via video, where it is a true and accurate representation of what's being said. You've got witnesses who see an event, or witnesses to the crime, for example. And then you've got other witnesses, like medical witnesses or expert witnesses, who have whose decision is and determination is really based upon science, rather than their perception of events as they're seeing them unfold at a scene. Isn't it true that the courts have been more lenient with witnesses who are scientific or medical witnesses who are more historical rather than of evidence that is of a nature that does not deal with the actual event being perceived by a witness, as opposed to those being perceived by a witness? Juries obviously want to be able to see how a witness may react to cross-examination, for example, or direct examination of how they are perceiving an event. But really, other witnesses who have have been brought into a case such as this particular witness in medical science, how can you articulate that there is a difference that protects this defendant under the Constitution where they have to be here in person rather than true and accurate representations real time of the person being perceived and being questioned not only by the prosecution on direct, but being cross-examined? Where is the Constitution not being met in those types of cases?
Well, Your Honor,
If
because.
you, if you can articulate.
Can, because of the nature of this case, because of the amount of time. The jury is, of course, the weigher of the credibility and the testimony. This case is totally based on DNA evidence, substantial, not totally, substantial. This person was very instrumental in recovering a lot of the samples that were used back then. And so I think that is important. I know what the court is saying, that you're trying to differentiate between a person that was actually, say, at the scene than a medical professional. But I think that
No, articulate to me how there is not a difference in confrontation of witnesses.
I don't think there is. I think that all
Okay.
witnesses,
Have to be
defendant's
present in
right,
front of a
that should
jury?
be, he should have a right to confront all witnesses that are not
Well,
testifying.
he is doing it by.
It's not the same as the court is well aware.
No, what it articulate, what the
But you
difference
look at
is.
the demeanor, you look at the testimony, you look at how.
Look at the
a
man,
witness answers.
where is his demeanor different than what you would see him here if his likeness was sitting in that chair?
What does
There
that,
he is.
what does that change with any witness?
It does to me with a live witness is going to be questioned about how they perceived an event. And I think a jury probably is interested in seeing how they may respond to, well, you weren't standing here. What if you were standing there? I mean, that's to me different from scientific witnesses where we're talking about a science he's testifying about rather than a perception by individuals who are imperfect.
Perception is that he was instrumental in procuring samples that were used for testing. Those samples have, over the years, have gone different places, but besides that, he was instrumental. And so I think that he should be right there so that
He's in the chain of custody is what you're saying at the end of the day.
chain of custody and what he did and the practices that he did, who was around at the time, and things like that, at the time of the offense. He may not have any direct knowledge of the offense, but he's instrumental in reference to why we're here today.
Okay,
And I think the jury should just video, I mean, it's not.
I know they
against the
should,
doctor.
but where's the Constitution says he has to be a live witness, especially in light of what he was going to be testifying to, which is science, and also the fact that he has a serious illness that makes his travel unavailable. Does that mean in those situations that a defendant does not have to answer for trial because someone is medically unable to safely travel in light of especially in light of the fact that all they're going to be providing for is a science answers of a questions dealing with a science, and the Zoom is going to show real time, not only his likeness, but his statements. He will be subject to cross-examination. And isn't it true that a jury, whether they're looking at him in a video or looking at him 10 feet away, aren't they seeing the same thing?
No,
And in fact, his likeness in that video right
Okay.
now is a closer look at the man than he would be here in person in
Well-
front of the jury, especially the jurors who are going to be 20 feet away from it.
right. So why aren't we all on Zoom?
Because what we want is to have the ability to have people, well, because we want it in live as
We
much
wanna
as we
see it.
can.
We want to
We
see.
want to, yeah, but in cases where it's necessary, what's the difference? Or what you're saying is we really want to turn all trials into a Zoom hearing matter. No, I don't think we want to, because we like to resolve matters where we are all together. But with science being the way it has encroached in that good feeling method of doing things. And it is important that we can resolve cases now in this way, in these type of circumstances. Otherwise, this man is unable to be here. He's a necessary witness. And if his condition is stable, he's unable to travel. So I know a defense attorney's position would be great. Let's dismiss the case because the necessary witness is not going to be able to travel.
But then, Judge, why during COVID, then it was the court's order or procedure to first say, does the defendant waive being here in court in person? And do you agree now to go to Zoom? Well, why would you give that waiver? Why would you give that warning if confrontation or being in front of the court was not important or a constitutional protection?
Because those were not issues dealing with a witness who is necessarily medically unable to be here. And they were witnesses who many times were folks who were witnesses of the event, again, that this court deems, in my education and experience, a person, a live witness is necessary for them, unless extraordinary exceptions, who witnessed the event. And that is something that a jury, I think, is best to see person to person. But when you have a witness like this, who is essentially a chain of custody in a science, I want you to articulate to me, what is the jury not seeing in this case, in this method, that they would see here in live person?
Well, first off, Judge, isn't COVID a medical condition that everyone took very seriously?
I'm just asking
Yeah,
you this right
but
now.
number
We
one
take it,
is-
we've taken it one step, and we have now, everybody feels more comfortable after COVID. The methods dealt with COVID have been employed. They feel more comfortable with the ability of electronics to work into a jury system. But once again, we're talking about since 1215, the jury system.
Sure.
So we're talking about 10 millennia of 1,000 years has gone by where there was a practice. And need I remind you, they didn't have a lot of Zoom back then.
Well, you're asking me to go now, next week, into the minds of 12 strangers
I'm
of
not.
what they may
I'm
consider
not,
or
of
not
course,
consider.
how can I do that? No, we're just
Well,
talking
because
about,
you're asking, what's the difference between live and Zoom to the jury? And I don't know who's going to be on that jury. And even if I did, I can't tell you what effect it will on the totality of the case. They may say, oh, no, I mean, because he said something or did something or he moved a certain way or his demeanor. I mean, and that's with any witness on that. And
what's your
just
point?
because.
But once again, what's
technology-
your point that you're not getting? What is the importance of the Constitution that you cannot see?
Confrontation,
Let me finish, that you cannot see with this man.
confrontation.
No.
And
You're-
the
no,
effect of
no.
somebody real,
Oh.
somebody that's human. And because we portray traits that directly bear on the credibility, the judgment of the credibility of the trier of the fact. And that's what they look at. It's, you tell them in their opening and in the jury charge and everything else that you are the judge of the credibility and what they say. And it's just like anything.
Anything else?
I just would want a little bit of time so I can,
You're asking, well, you're gonna get with me tomorrow, but you said you needed until.
I just
it's
need
got
something to go
look
back.
it
I got this
Fine.
this morning, Judge.
All right.
And I'll address the issues in reference that you brought up during this hearing,
Okay.
and address those.
All right. The court is going to be inclined what it knows and what it has experienced in my 4 years of practice in dealing with this is that now it Zoom hearings are obviously a method that is newer to the practice of law than the old methods. The question is, are they just as good or better to satisfy the constitutional requirements, especially in limited purposes? In limited purposes, we don't want to open the door to all trials being Zoom. I think that would be a terrible thing. But in limited purposes and limited situations, until you can articulate, you keep saying generalities, you can't articulate to me successfully yet that what you're seeing in this man is something that is different from what jury would perceive if the man was sitting. And you have to admit the perception, he is even closer to the viewer under this Zoom than the jury would see him in live person. He would be farther away. And again, with his limited part of this trial's, the state's presentation, we're dealing with a science rather than a perception of what he may have seen or heard at the time of a scene of an event. And when it is limited as a chain of custody of a science, and he is being presented for cross-examination, and he is being viewed closer in range in this Zoom than he would be if present in live performance in front of a jury. This court does not see any constitutional infringement. Anything else? You'll
No.
get back with me though.
Judge, for appellate purposes, can we go into this just for purposes of the hearing?
Yes, you're talking about
States one.
here. Can you date it for me today's date, please? And then, and you got the cause number in it.
So is your ruling, Judge, that he's only going to testify to the chain of custody?
What does the state said he's going to testify to? That's what I understood.
He's going to testify to the autopsy and the chain of custody.
That's what he said.
That's it.
So it's more than just a chain of custody.
All right, the autopsy and the chain of custody. Yeah, whatever it is they say, but look, I don't do autopsies, only science does. It's the experts in science and then, but my ruling is it included it being based upon a science that has been accepted in the history of jurisprudence in the United States, autopsies being science.
Not arguing a reference to autopsy, Judge. What I'm arguing is that your distinction was this was just he was going to testify to the chain of custody, and it's just not that. He's going
Good
to have
point.
to testify to
Good
the cause
point. They're
of
gonna-
death and what he observed and things like that.
Once again, my rulings stay the same, whether it's the autopsy and chain of custody or chain of custody or autopsy. Again, he's not a live witness of an event, seeing the event where his perceptions of how he may have seen it and what he saw, how he saw it, what he heard are challengeable and or subject to rigorous cross-examination. He is going to be testifying chain of custody and as a science in an autopsy, a method that has been long accepted as an appropriate method of proving cause of death. And for no other purpose, correct?
That's correct.
Yes. But it's subject to what you see, what you give to me until this trial begins.
Thank you.
The more information I have, the better I can make a ruling, but that's the tentative ruling at this time. Thank you. That is all. Okay. Here. Yes.